The SEC is raising the bar on who qualifies for performance-based fees, and the impact will be immediate for investment advisors and fund sponsors. The Securities and Exchange Commission has proposed new inflation-adjusted thresholds under Rule 2053 of the Investment Advisors Act, and effective June 29, 2026. These changes will directly affect when advisors can charge performance-based compensation, including carried interest, incentive allocations, and fulcrum fees. So what's changing? The order issued by the SEC increases the assets under management threshold from $1.1 million to $1.4 million, and the net worth requirement from $2.2 million to $2.7 million. These thresholds determine whether a client qualifies as a qualified client, a key requirement for entering into performance fee arrangements. And timing matters here. The rule was expected to become effective about 60 days after final issuance. Based on the March 27, 2026 notice, the SEC has set June 29, 2026 as the effective date of the proposal. That creates a short window for firms to evaluate onboarding pipelines, update documentation, and prepare for compliance. Here's where the real impact shows up. This change reduces the pool of eligible investors. Even if an investor qualifies as accredited under Regulation D, that alone is not enough. They must meet the higher qualified client thresholds to participate in performance fee structures. That distinction is critical, and it's often misunderstood. For advisors and fund sponsors, this means increased scrutiny on onboarding processes. Investor questionnaires, representations, and verification procedures will need to be updated to align with the new thresholds. From a capital formation perspective, this could also create friction, especially for funds targeting emerging high-net-worth investors. Firms may need to rethink minimum investment levels, marketing strategies, or even share class structures. There are also important implications for transfers and secondary transactions. New investors, and even existing investors increasing their positions, will likely need to requalify under the updated thresholds after the effective date of the order. Now, what about existing clients? The rule is not retroactive. Advisory contracts that met the requirements at the time they were signed will generally remain valid. But there are limits to that protection. New investors admitted after the effective date must meet the updated thresholds. And certain changes, like transfers of interests or material amendments to agreements, could trigger requalification. This creates a clear need to distinguish between legacy and new investors in your documentation and compliance processes. So what should firms be doing now? Start preparing. Update advisory agreements, subscription documents, and investor questionnaires. Review onboarding procedures to ensure they support proper verification. Evaluate fund governing documents, especially around transfers and admissions. And make sure your investor communications reflect the coming changes. The bottom line is this. This is a routine inflation adjustment, but with real operational consequences. It narrows the investor pool, raises compliance expectations, and adds complexity to fund operations. Firms that act early and align their documentation and processes now will be in the strongest position to be in compliance with the new rule when it takes effect in June. If you have questions about how these changes affect your firm, now is the time to take a closer look. At Legay Law, we make regulations make sense. For more regulatory updates, subscribe at legaylaw.com.